The headline of the Jamaica Observer on Tuesday, April 30th, shouted, "Cabinet divided." The gist of the story was that some members of the cabinet favored appealing the judgment of the Supreme Court that the NIDS Act is unconstitutional, while others, including Prime Minister Holness, favored going forward by fixing the law. My reaction was in favor of the approach of the Prime Minister. During 2018, I had attended a town hall meeting at the Bethel Baptist Church where a panel of NIDS officials outlined what NIDS was about and answered questions. I have been a supporter of a national ID number. However, I concluded that this latest NIDS initiative would prove to be unimplementable because it was too omnibus in scope and not principally focused on a national ID number, too granular in the biographic, biometric, demographic, social, and economic data demanded, draconian in approach, colonial in mindset, treating people as subjects and not citizens with rights, willfully ignorant of the work of the Registrar General's Department and of the Electoral Commission, cavalier in its proposals for accessing the database that would be created, manifestly naive about the consequences of the planned overreach of the state, and unrealistically ambitious in its time frame for implementation and needlessly expensive because of the duplications that would be involved. Based on my experience, Jamaicans of all walks of life and levels of responsibility were unlikely to comply with and provide the cooperation necessary for its success, even where the coercive power of the state is so openly invoked, where a people schooled in resistance and not easily frightened by threats, even by the state. I had not seen the legislation and was completely surprised that the Supreme Court ruled that the entire NIDS Act was unconstitutional. My immediate reaction was good. We have a chance to think again and be more realistic. The Observer headline, however, impelled me to go to the Supreme Court website and read the judgment by Chief Justice Brian Sykes, Justice David Batts, and Justice Lisa Palmer Hamilton. Let me immediately acknowledge that several of the legal constructs, especially related to presumption of constitutionality, severance, proportionality, and privacy, are beyond my layman's conceptual understanding and therefore is limited to grammatical meaning. I will therefore leave it to members of the learned profession to debate the legal substance of the judgment. As a layman, however, I was hooked on the judgment from the very first sentence. Dissent has had a troubled history. I could not put it down. The judgment is breathtaking in its scope and scholarship, brilliant in its analysis of sources cited and position taken by counsel on both sides, brutal in its rejection of spurious evidence and errant arguments, beautiful in the clarity of its prose, bold to venture beyond the complaint of the plaintiff and to strike down the entire law, and boisterously belligerent in its stated adherence to the doctrine of the separation of powers and the role of the judiciary in a free and democratic society. This is not advocacy for the beatification of Justice Brian Sykes, Justice Batts, and Justice Palmer Hamilton as saints of the Jamaican judiciary, nor any suggestion that the judgment should be canonized as scripture. Rather, it is the adulation of an elderly layman, buoyed in spirit by the clear evidence that the current justices are worthy successors of the legal giants that preceded them. Our high courts appear to be in safe hands. This judgment seems to be a seminal judgment which members of the learned profession, information professionals, policy advisors, senior bureaucrats will have to contend with for years to come. It seems to have brought and applied the best available jurisprudence, especially from the Anglophone world, to this Jamaican case, and then advanced Jamaican and Caribbean jurisprudence through its argumentation and ruling. My only problem with the judgment is with respect to a legal term whose meaning I understand. That legal term is notorious fact. This is a fact that almost every adult in a society knows. It is a notorious fact in Jamaica that the Electoral Office has been collecting and using biographic, biometric, and demographic data for the purposes of identification and authentication. Yet, this notorious fact is absent from the judgment. It is not mentioned by the plaintiff, nor the defendant, nor the esteemed justices. The notoriety of this fact derives from the personal experience of every person who has applied to register to vote in Jamaica. Since 1997, mock exercises in numerous communities across the country, frequent reports in the press, the media, and online, publications of the Electoral Commission, published reports of local and international observers of Jamaican elections since 2002, and a book written by Mr. Ryan Peralta Sr. The use of biometric and biographical information to identify persons is a principal component of the contested legislation. Paragraphs 230 to 246 of the judgment, under the heading "The Nature of Biometric Systems," review principles, procedures, experiences, and decisions about the nature of biographic data in many countries across the world. The omission of this notorious Jamaican fact immediately attracted my attention. I refrain from any speculation of its omission, but I am obliged to comment on the use of biometric and biographic information for identification and authentication, because while it was not critical to the judgment, it is very germane to the way going forward for a multiplicity of reasons. Jamaica was the first country in the world to use biometric data for identifying persons outside of forensic settings and in its general population. The idea arose in the Electoral Advisory Committee, and member Ryan Peralta, then chairman of the Jamaica Labour Party, with the permission of the EAC, applied for and was granted the US patent for this technology. It was one of the first occasions that the US Patent Office granted a patent for an idea and not a device. The patent included all biometric characters, although the application was for fingerprints. Professor Laurie Reed of the University of the West Indies chaired the technical committee for applying this technology to the electoral process, and Mr. William Chinsey, QC, chairman of the EAC, played a leading role in crafting the legislation for the use of this technology in the electoral system. When the electronic voter identification and ballot issuing system was first used in a by-election in 2003, Jamaica led the world in using biometric characters stored in a database to be matched with live biometric features of persons, and on a match issuing an action, in this case a ballot. The United States was the first to use this paradigm at its borders and employ the same company that the EAC contracted through international tender to implement this system in Jamaica. Since 1997, over 2 million Jamaicans and Commonwealth citizens residing in Jamaica for over 6 months have voluntarily provided biometric information to the Electoral Office. Jamaica has had continuous registration of voters since 1998 and produces 2 voters lists per year. Every voters list since 2001 has been prepared by cross-matching the fingerprints of each applicant against every other applicant and against everyone who has applied to vote since 1997. Every elector is on the voters list only once. There is no duplication. Studies of the EAC comparing voter registration data with census data gathered in the census year show that voter registration increases progressively from just over 50% among 18-year-olds to more than 90% for each age cohort 30 years and older. This means that more than 80% of Jamaicans over 18 possess voter ID cards, while only about 50 to 60% actually vote. This is empirical evidence that the voter ID card is sought for purposes other than voting. The legislation permitting the collection of biometric data precludes these data from being shared with any other agency, public or private. These data have never been shared, notwithstanding considerable pressure to do so. The voter database has never been hacked because it cannot be hacked. The database is not online, inside or outside the electoral office. Physical access to this database is highly restricted, and action on the database are even more restricted. The individuals so authorized are protected with anonymity. There has not been a case of any allegation of any sort of abuse brought against the electoral office for lapses in the custody of this biometric information. Because biometric data vary in quality, resulting in possible errors, the electoral office has developed great expertise in dealing with false positives and false negatives. Because false positives are catastrophic to identification, declaring persons to be so when they are not, cross-matching of stored and live data is biased in favor of false negatives, declaring that persons are not so when they are. Strict procedures have been developed for resolving false negatives, which occur with every generation of every voter's list and with every use of the electronic voter identification and ballot issuing system. In a nutshell, the experience and expertise of the electoral office far exceeds what is described in paragraphs 230 to 246 in the judgment. The use of biometrics in the electoral process in Jamaica has been one of the pillars which has advanced Jamaica as a free and democratic society. The fidelity and competence with which the electoral office has protected and used this very sensitive and private information has earned the trust of the general population, which in turn has elevated the status and the desirability of having a voter ID card. This is particularly so for older adults who have not been able to fulfill the requirements for obtaining a birth certificate, but can qualify for a voter ID because they can provide the biometric information, provide proof of residence, and easily satisfy officials of the electoral office and scrutineers from the recognized political parties that they are over 18 years of age. The voter ID card is the only official ID that many Jamaicans have. In addition, the security features and quality of this card has earned the confidence of financial and other institutions. It is for these reasons and circumstances that the voter ID has been elevated to the status of a de facto national ID. This is the third attempt to create a national ID. I am not sure why the first attempt was unsuccessful. The second attempt failed for lack of financing. This third attempt has attracted significant financing but has failed the test of constitutionality. Most significantly, the court has ruled that collecting biometric information from minors cannot be justified. The implication of this is that fixing the legal defects of the NIDS legislation will not make it applicable to minors. With respect to the population 18 years and over, the esteemed justices ruled that compulsory demand for biometric information by the state violates the individual's right to privacy. The NIDS initiative and legislation was predicated on the assumption of essentially starting from scratch with a wish list that has proven not to be viable. That does not mean, however, that there is no way forward. Barbados has long had a national ID system which includes minors. The Barbados national ID system does not collect biometric data from minors. The Barbados system is strongly aligned to its system of registration of births and deaths. Seeing that the Jamaican government has obtained significant resources for creating a national ID, a two-pronged policy option seems worthwhile. One prong would be enhancing and strengthening the Registrar General Department to issue a unique national ID number from birth, and that would be immediately implemented for minors up to 5 years of age. Children entering the school system would be the immediate beneficiaries. The second prong would be to upgrade, update, and strengthen the Electoral Commission so that its legislation satisfies all of the provisions of the Jamaican Charter of 2011, and its technology is brought up to the state-of-the-art level. The Electoral Office is still using, in 2019, essentially the technology it started with in 1997, despite the great advance in the power and the capabilities of that technology generally. And the third element would be to assist the Electoral Commission in its action to increase voter registration among 18 to 29-year-olds. Within 20 years, both of these prongs will become integrated. Persons who do not choose to register to vote will have a unique national ID number that never expires. Those who choose to register to vote would have a national ID with all of the biometric and biographic features outlined. We are a young country. Success resides in building on the achievements and accomplishments of the previous generation and advancing them in each succeeding generation.